perception that there are a cohort of doctors out there who are either not particularly concerned as to what they write. So this isn't about quality of reporting, this is that they may have a suspicion that the claimant isn't as injured as he says he is or isn't injured at all, but it's just too much hassle to actually write that in a report.
LASPO, frankly, and the ban now, whether you agree with it or not, seems to have been fairly widely sidestepped, quite frankly, by claimants, and they've worked out how to get around this. I don't think we should assume that, our clients, the public out there who are over 18 and of sound mind, shouldn't be able to make some decisions. I actually want the market to break up so that people can pick between the good and the bad solicitor.
There's a lot of things that the rest of the legal services market could learn from personal injury. We, as our regulatory discussions tend to focus on, we're concerned that there's a significant number of consumers that don't get access to legal services when they have a problem, that don't seek professional advice. We actually could learn quite a lot from this sector, which could be relevant to other parts of the legal market.
I'd like to start off with a question for everyone. Can you imagine driving down a country lane at night with no lights on, looking out through the back window? Sounds pretty impossible, doesn't it? But that's what I think about the future of the industry over the next 5 years. There's still lots of reforms still washing through, and probably we won't know the real impact of those until 6 or 12 months down the line.
I understand what Niall said from Kennedy's earlier about defendants welcoming fixed fees but not in their entirety. I'm not sure that's right. I'm sure if you get a defendant in a darkened room, he'd probably say, I don't welcome fixed fees at all because they squeeze my own productivity and profit, but you can't bite the hand that feeds, and when you work for insurance companies you have to be seen to toe the line.
People are becoming addicted to video, whether that be to entertain or to inform. And in the UK we have 32 million folks that are active every day on our YouTube platform. So that's the next big thing, video as a way to distribute content, to get yourselves known and to educate the user before they then engage and want a discussion about potentially using a service. You've got to be on video.
If you want to move into disease and clinical negligence, you've got a disbursement issue. You've got to fund these cases. They're not going to settle like RTA cases. They can take 2, 3, 4 years.
Spending your advertising dollars on no win, no fee, £20 a click or whatever it is, it's really naive. I would much prefer to spend my money on sort of investing in, say, a client first response team that meant that every time someone went on my website and we said, do you want to have a chat, that we could deal with them directly on the website and just interact with them and get them straight away. Because I think that there's so many different ways of getting clients, and as lawyers we just haven't thought about it enough because we've been too busy being lawyers.